counsel for the petitioner, Avante Villa at Jacksonville Beach, a skilled nursing facility in Duval County, Florida. I would like to reserve 3 minutes for rebuttal. The underlying case involves a claim for nursing home negligence against Avante under Chapter 400 of the Florida statutes by a representative of Darlene Payson, a former resident of Avante. The instant appeal is from a discovery order in which the trial court held specifically that Amendment 7, that is Article 10, Section 25 of the Florida Constitution, applies to skilled nursing facilities, and that Amendment 7 preempts any and all quality assurance privileges previously enjoyed by skilled nursing facilities. The trial court's order is a departure from the essential requirements of law for two main reasons. First, skilled nursing facilities are not healthcare providers as defined by Amendment 7, by its implementing legislation or by the general laws of Florida related to a patient's rights and responsibilities. Second, even if skilled nursing facilities were intended to be encompassed within the scope of Amendment 7, application of Amendment 7 to skilled nursing facilities would be impermissible under federal law governing skilled nursing facilities. Did
you raise that issue in the trial court?
No, Your Honor. Actually, the issue in the trial court was whether Amendment 7 applied to skilled nursing facilities. And
can we reach that issue at this point?
Yes, Your Honor, you can.
Why?
Because any controlling statute is taken under judicial notice by the trial court. In a case out of the First District, Jacksonville National Bank, or Barnett v. Jacksonville National Bank, there was a similar issue, and a controlling statute was not addressed until the time of the appellate court, until the time that the appellate court addressed the case. And it was held that where a controlling statute is not brought up to the trial court, the appellate court must nevertheless follow it. And
was that an affirmance or reversal?
Pardon me?
Was that an affirmance or reversal in that case?
That was a reversal, Your Honor. As to our first point.
I'm not sure I'm quite ready to leave that one yet.
Yes, sir.
The Missouri court has interpreted the federal statute to just apply to the committee's notes and minutes from the assurance committee. Why shouldn't we interpret the federal statute the same way?
Your Honor, the issue before the court today is not whether the particular items that have been compelled by the trial court are or are not privileged. The issue is whether that a privilege exists at all. In other words, the trial court has requested that certain items be provided for in-camera inspection, but the trial court has precluded the possibility that any of those items will be excluded from discovery.
If we agree with you on the federal question, the appropriate remedy would be to send it back to the trial court to determine the scope of the federal privilege and whether those documents are within that privilege.
If you agree on the preemption issue, Your Honor?
Yes.
Yes, sir. As to our first argument that the plain language of Amendment 7 excludes long-term care facilities, Amendment 7 provides that patients have a right to have access to any records made or received in the course of business by a healthcare facility or provider relating to any adverse medical incident. Luckily, the amendment contains a definition section for guidance, and it provides that healthcare facility and healthcare provider shall have the meanings as given in general law relating to a patient's rights and responsibilities.
Let me help me there, though, because related to a patient's rights and responsibilities.
Yes, sir.
Does that mean that the entire section or the statutory section has to be related to patient's rights and responsibilities? Or do we look at any section that has anything to do with the patient's rights and responsibilities? Well, you understand my question? There are a number of statutes in statute books that define healthcare facility. And part of those particular statutes, the sections, the purpose or the, may deal with patients' rights and responsibilities.
Absolutely, Your Honor. And healthcare facility is one of those terms that is defined variously in the Florida statutes. In Chapter 766 alone, healthcare facility has 3 different definitions. And that is why the definitional section in Amendment 7 is so important, and those words, patients' rights and responsibilities, are so important to us. There is one statute in particular in the Florida statutes, that is Section 381.026, which is entitled the Patient's Bill of Rights and Responsibilities. It makes the most sense to take a look at the definition of healthcare facility within that statute. In that statute, Your Honor, a healthcare facility is defined as a facility licensed under Chapter 395 of the Florida statutes, which is a hospital. Healthcare provider refers to a physician licensed under Chapter 458, an osteopath licensed under Chapter 459, or a podiatrist licensed under Chapter 461. These definitions reflect the intended scope of Amendment 7, and the exact wording was carried over into the implementing legislation at Section 381.028.
Is there anything in the history of the adoption of this constitutional amendment that sheds some light on this definition?
Actually, yes, Your Honor. While the Floridians for Patient Protection have filed an amicus brief in this appeal today to contend that nursing homes and long-term care facilities were always intended to be within the scope of the amendment, during the ballot approval process, the Floridians for Patient Protection filed a number of briefs at the Florida Supreme Court level and took the opposite position. I found one brief in preparing for today's hearing at 2004 WL, as in Westlaw, 1574738. And that brief was submitted in opposition, actually, to the financial impact statement. And if I may quote from it, the Floridians for Patient Protection presented to the Supreme Court that the proposed impact statement predicts costs related to nursing homes and assisted living facilities, neither of which are actually within the scope of the proposed adverse medical incidents amendment. In addition, all of the information provided by the Floridians for Patient Protection, who were the sponsor of the initiative, on their website referred to hospitals and physicians, but not to nursing homes or assisted living facilities. The proposed ballot, the proposed text of the amendment, and the ballot summary, none of those referred to nursing homes or assisted living facilities. I do have...
Are all nursing homes necessarily the same in terms of whether there's various levels of health care provided? I'm aware that there are nursing homes who actually have doctors on staff, and that there's basic health care provided. And there are other nursing homes that are simply residential. How do we deal with that situation?
Your Honor, I think that's a very good question, and certainly there are nursing homes that do employ medical directors, for example, and other medical staff. Other nursing homes outsource for these services. And it's, Bravante is not arguing that an adverse medical incident cannot occur in a nursing home under the supervision of medical staff. But to say that Amendment 7 applies as a matter of law to nursing homes is overbroad.
But definitionally, how do we deal with that? I mean, you're proposing a definition under Amendment 7 that excludes nursing homes.
Yes, sir.
It excludes nursing homes that don't otherwise provide health care. I mean, I'm concerned about the impact of a decision down the road.
I think what we are proposing, Your Honor, is that a definition similar to what the Supreme Court found in Integrated Health Services v. Redway. The distinction would be between the nursing home itself and the nursing staff versus any medical staff that may be supervising directly the patients. As to our
let's follow up. What if an adverse medical incident occurred at the nursing home, and somebody wanted to look at the, what adverse actions had occurred at the nursing home? How would they get those records? How would they know to get those records?
I'm not sure I understand your question, Your Honor.
Okay, I think you said in answer to Judge Van Nortwood's question that the physician would be covered under the term healthcare provider.
Yes, sir.
So those records would be available.
Yes, sir.
As far as the physician.
Yes, sir.
Okay. So the way that someone going into a nursing home wouldn't have these things available would be to say which physicians you have on staff,
That's correct.
and then they have to go through the physicians.
That's correct, because the physicians are subject to separate reporting requirements for the adverse medical incidents.
Okay.
An adverse incident under Section 400.147 is not an adverse medical incident, and this distinction makes sense for the same reasons that it makes sense to exclude nursing homes from the medical malpractice statute. Chapter 400 provides a distinct standard of care, separate rights for the nursing home residents, and different protections for quality assurance. And further, even if adverse incidents as separately defined in Section 400.147 are adverse medical incidents pursuant to Amendment 7, disclosure of this information would be inconsistent with the mandates of the Federal Nursing Home Reform Act.
Okay, you mentioned the statute that was passed by the legislature to implement Amendment 7.
Yes, sir.
This court, and at least the 5th District, have held that that provision is self-executing.
Yes,
How
sir.
much leeway do we have to go into the statute based on the finding that the amendment was self-executing?
Well, I believe, Your Honor, that the concerns of this court were addressed in a new version of Section 381.028, which, in this court's opinion in Notami Hospital v. Bowen, there were some concerns with the limitation of the types of reports that would be available. There were some concerns regarding the preservation of peer review privilege. The Bowen case did not address the issue of whether Amendment 7 was applicable to nursing homes.
I understand that, but when the court determined that the provision was self-executing,
Yes, Your Honor.
that, in my understanding of what self-executing means, it has to be sufficiently clear so it can be implemented without legislation, which means the legislature generally cannot change the terms of the amendment, which is what Notami Hospital and all those get to.
Yes, sir.
So my question is, based on the prior finding that this amendment was self-executing, how much can we look at legislation in order to help us?
Well, Your Honor, the definitions in Section 381.028 were not challenged by any party, particularly the definition of healthcare facility and healthcare provider, which were carried over into the new version of the statute. But our position is it is not necessary even to look at Section 381.028 because the definition contained in Amendment 7 is specific enough, as you said, containing that language, meanings in general law as relating to a patient's rights and responsibilities. That is sufficiently clear and unambiguous that we don't need to look at the implementing legislation.
But if that's the case, and we exclude the implementing legislation, what general law was the constitutional provision referring to?
Section 381.026, Your Honor, the Patient's Bill of Rights and Responsibilities. That section contains definitions for healthcare provider and healthcare facility, which are consistent with our position today.
Okay, but, the language in the Constitution doesn't say to the patient's rights and responsibilities, which would lead us right to that statute, but says to a patient's rights and responsibilities. So that, again, can't we go looking at all the provisions of the Florida statutes or chapters of the Florida statutes that deal with the patient's rights and responsibilities?
I think, Your Honor, that the most logical step would be to look at the language of the statute that follows the language of the amendment. In other words, we have an amendment that says these words will be given the meaning as they have in law relating to a patient's rights and responsibilities. We have a law entitled Patient's Rights and Responsibilities, which confers rights and responsibilities on patients. It makes the most sense, therefore, to look to this law for the scope of the definitions. And I see my time is up. Thank you very much, Your Honor.
May it please the Court, I am Philip Burlington here on behalf of the respondent, Charlene Breeder, personal representative of the estate of Darlene Payson. I'd like to get out of the way first the federal issue because I don't think it should be reached by this court. I recognize this court has the authority to consider controlling statutes that are not raised below, but the circumstances are limited, and this is a situation in which it would be inappropriate. I say that for two reasons. First, as she has candidly admitted, they didn't raise it below, and the suggestion that you can now apply it to this order, I would submit you have an inadequate record, and you would be, to a large extent, operating in a vacuum, because the federal statutes are very specific on what they deal with disclosure of documents. And they, by their terms, do not apply unless, and they don't use the term nursing home, they talk about skilled nursing facility and so forth, but their definitions require certain factual predicate which has not been shown to exist here. Now, some of the...
Well, let's take the Missouri definition, for example. In the Missouri case, it talks about the notes and minutes of the assurance committee or whatever committee it's called. If there are, in fact, documents covered within your request that are within those committee notes and minutes, shouldn't we be sending this back to the trial court?
Well, here's the confusion on that, and that is possible, but here's the difficulty. There is in Florida Statute 440.147, sub 1B, the requirement that a nursing home have a quality assurance committee. That's what we asked for. In the federal legislation, they talk about quality assessment and assurance committee. So technically, we didn't ask for the committee information that they claim might exist. It is a different name. Furthermore, whether the committee has the appropriate makeup, because not only does the federal statutes and regulations require this committee, it requires that certain people have to be on it, and it defines 3 categories of people and certain numbers for each. So the trial court would really have to have at least one more evidentiary hearing to establish not only that this facility qualifies for application of these federal statutes, but also that the committee was made up in accordance with the federal statutes, and that it operated, and there are other requirements of when they have to meet, and so forth. I would submit it is inappropriate for this court to have to deal with those uncertainties, send it back for something that might be a meaningless exercise. You do have the authority to do so. The trial court has taken the matter for in-camera review and has stayed particular documents, so what you're saying is not impossible. But I would submit that this case does not lend itself to that consideration. But if this court does reach that issue, it is limited to the documents generated by that committee. And not only has the Missouri Supreme Court ruled that way, but New York has as well, that a facility cannot create a new privilege by taking documents generated outside the committee, presenting them to the committee and saying, oh, now it's a record of that committee. It would be limited to that committee's own documents that they generated.
Well, help me more with this, going to the other point, the one that I think is of concern. You know, the phrase healthcare facility in the definition in Amendment 7.
Yes.
Healthcare provider, healthcare facility, that would seem to include nursing homes, generally you would think of that.
Yes.
But then the language, meaning given in general law related to a patient's rights and responsibilities.
Correct.
That's the hang up here. There's only one statute that specifically deals with a patient's rights and responsibilities. And that statute excludes nursing homes. I mean, there are other statutes that deal generally with the subject of patient's rights and responsibilities. The patient's rights and responsibilities are outlined in Chapter 381.
Well, Your Honor, here's the difference. The term patient in the amendment is not defined as accordance with general law. It is a very broad definition as noted in the Buster decision. And it is...
Why is that so?
Excuse me?
Why is that so? Why is it not defined just as it is in general law?
Because what the amendment says, whereas it says healthcare facility is defined in terms of general law, what it says with patient, it says an individual who has sought, is seeking, is undergoing, or has undergone care or treatment in a healthcare facility or by a healthcare provider. When you look at Chapter 400, which regulates nursing homes, the title of that chapter is Nursing Homes and Related Health Care Facilities. And that chapter defines, and they call them residents, but the residents clearly would fall within this definition of patient within the amendment, because it does not exclude anybody according to the nature of the facility. It talks about any individual who will sought medical care or treatment in a health care facility, clearly a person seeking care or treatment in a nursing home, where that is defined in Chapter 400 as a health care facility, not only in the title, but throughout various provisions, and I've outlined those in my brief. The only reasonable construction is that that includes nursing homes. And the construction of a constitutional provision, as I've discussed in my brief, is not limited as a statutory provision is.
Okay, but if we don't limit the phrase to the one statute dealing with the patient's rights and responsibilities specifically,
Correct?
aren't we going to get inconsistent definitions?
No, because there is a specific definition in sub 2 of patient. There is a specific definition in 1 about healthcare facility, and it does not, the 381026 is called the Florida Patients Bill of Rights, and it relates to patients in hospitals. When the phrase is used in healthcare facilities, it just says general law related to a patient's rights and responsibilities. It doesn't cite this particular statute.
Yeah, but aren't there a number of different statutes? If we take what you're arguing, aren't there a number of statutes that deal with a patient's rights and responsibilities?
In different facilities, yes. But with respect to nursing homes, that would be Chapter 400, which specifically describes nursing homes as health care facilities. So that is the one that has 400.023, which has the rights, and I think they call it a Bill of Rights of nursing home residents. But I mean, that's the chapter that does it. I have cited many other statutes in my brief, but the purpose is to show that this is a recognized definition of a nursing home, healthcare facility, a recognized synonym for nursing home. And common usage is obviously relevant to interpreting any provision, constitutional or statutory. But the standard that applies here.
But this doesn't say we use a common definition. This says we use the definition given in general law.
Correct. But the definition for patient doesn't require reference to general law. So if they describe it as a patient, as someone seeking treatment in a healthcare facility, and in general law, a healthcare facility is synonymous with nursing home, that should be sufficient. And again, what is clear from the Florida Supreme Court decision in Coastal Florida Police Benevolent Association is that the literal definition of terms in a constitutional provision do not define its scope and purpose. It is the intent of the voters. And the voters.
Counsel, return for a moment, if you would, please, to Chapter 400. And you've referred a number of times, and your brief refers to nursing homes being defined as health care facilities. I'm not sure I can read that the definition of a nursing home to be a health care facility. It speaks in terms of related nursing homes as an identifiable entity and related health care facilities. It doesn't say nursing homes which are health care facilities.
Correct. But when you look at Section 400.147, which is part of that chapter, and it talks about the internal risk management and quality assurance privilege, it imposes the duty on all agents and employees of the licensed health care facility, and it's referring to nursing homes in that statute. So the very privilege they're relying on defines or says is synonymous with nursing home, health care facility. And so I submit that the title of that chapter and the statute that talks about the obligations they have in order to generate information on quality assurance describes them as a health care facility. Now, again, it is the purpose of this act, of this amendment, which should control, not the literal meaning. They have tried to pick out particular definitions and say we don't fall within that. They have never given you a rationale as to why the voters would have excluded nursing homes, which by their nature provide medical care. And when you look at the definition of a adverse medical incident, it includes any other act, neglect, or default of a health care facility. So it doesn't limit it to medical in the literal sense. It talks about any neglect or default by a health care facility. So, and then in this court's decision in the, I believe it's Notami versus Bowen, it talks about how it is broadly stated that the public should be entitled to any adverse medical incident reports and documentation, and that it was very broadly stated that that was their intent. I would submit it is inconsistent with that intent to take away what is recognized as one of the major facilities for providing medical care to residents of Florida. There's nothing in the Act that supports that. They are trying to treat this as a statute, take literal definitions, and find their way to be excluded from it. Now, I heard in the argument, and I have never seen this brief of the FPP, nor have I looked on their website, that they apparently expressed some opinion about a financial impact and it wouldn't affect nursing homes or assisted living facilities. I don't know the background of that. I don't know at what stage that was stated. There is nothing in the ballot summary. There's nothing in the language of the amendment, and that is what the voters voted on. If this court needs a more detailed response, unfortunately, since I've never seen it before, I would request you give me the opportunity to file some kind of supplement, because I have not seen this. But the entity that promotes the amendment does not itself get to define its terms once it is enacted. That is by what the intent of the amendment is as reflected in the ballot summary and in the terms of the amendment itself. And here there are clear indications that the public intended this to be as broad as it could be construed to apply to adverse medical incidents, which we all know exist in nursing homes. And there was a question about whether there have to be doctors in nursing homes and so forth. I would note that with respect to the federal issue, one of the requirements to fall within the federal provisions is that there be a physician who is appointed as the medical director of the facility, and he has to be on the committee, which is the Quality Assessment and Assurance Committee. So clearly the federal government recognized that this is a situation where medical services are provided on a regular basis, and they have a very limited privilege for very specific documents, and I would submit that they have not preserved the issue, nor should this court reach it here. But the point is that anyone looking at the nature of this amendment and the public's intent, it was that they no longer believe that it is appropriate for them to be deprived of information regarding the quality of the health care that they are either obtaining, have obtained, or decisions that they are about to make. And to exclude nursing homes from this would defeat that purpose, and no constitutional provision should be construed in a manner that would undermine it. I believe we fall within the literal definitions, but even if we don't, that is not the standard under the Florida Supreme Court cases, which this court has also referenced, I believe, in the Notami case, and the 5th District noted them and relied on them in construing Amendment 7 in the Buster case. So for those reasons, we don't believe that it has been demonstrated that the trial judge departed from the essential requirements of law. He applied the literal language and the broad intent of this amendment properly, and determined that based on what was presented to him, his order, which prevented us from getting certain things, but made very specific determinations per committee, it limited the time frame, it required in-camera inspection for relevancy prior to our getting it, that it was a very well-reasoned order and it should not be quashed. Thank you.
I don't have much time, so I'll just briefly.
I got one more question for you.
Yes, sir.
I'm aware in cases that say, when there's an amendment put on by the Constitutional Revision Commission, we can look at the notes of the Revision Commission. When an amendment's put on by the legislature, we can look at legislative intent. On an initiative petition, though, is there any authority to say that we get to look at the intent of the framers or the intent of the people that put it on there?
Your Honor, there is, if you give me one moment, I can find that for you. It is Zingale v. Powell.
Pardon?
Zingale v. Powell. Give me one moment.
Doesn't that have to be proved up in the trial court?
And that's a 2004 Florida Supreme Court case.
And what was the name of the case again? Just give it to me.
Zingale v. Powell.
Okay. Now, when we're looking at Constitutional Revision Commission, and we're looking at the legislative documents, we're talking about official documents of those bodies. And we're case where we're talking about an initiative, and we're not talking about official documents of an official body. Shouldn't that be something that's proven up in the trial court so it can be challenged?
The intent of the voters, Your Honor?
Well, I'm talking about the intent of the parties, the initiative process. Because it seems to me that the initiative is a little bit different than these other methods of putting things on the ballot.
Yes, sir.
And, we're looking at the intent of the people. So the first things are some ballot summary and what they have in front of them. But it seems the question that you're raising right now, that we can look at the intent of the framers of an initiative petition, seems to be an entirely different story. And to be able to prove up that intent seems very difficult to me. And shouldn't it be something that's, subject to challenge in the trial court?
I believe it should be subject to challenge in the trial court.
Okay, so your argument concerning, the initiative, what the people that put the initiative on the ballot, we don't have any of that in front of us on this record, do we?
No, Your Honor.
Okay, thank you.
And I see my time is up. Thank you, Your Honor.
Thank you, Counsel. Next case on the calendar is